Alrighty, this is We the People News. Okay? Not an attorney, not giving legal advice. Educational purposes only. And never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Okay? You guys know the rest. I'm going to just make this short and sweet. It's probably going to be a two-part video because we really need to know the intent of the original to what we have today. And they kind of go into both of these. And a lot of this is accurate. But if you listen to the words, it kind of contradicts itself. And we're going to go with the Sixth Amendment. And what is it?
Hi, this is Kim from Khan Academy. Today I'm learning about the Sixth Amendment to the U.S. Constitution, one of 4 amendments in the Bill of Rights that concerns the rights of the accused. The Sixth Amendment guarantees defendants in criminal cases the right to a speedy and public trial. To learn more about the Sixth Amendment, I sought out the help of 2 experts. Stefanos Bibas is a United States Circuit Judge for the U.S. Court of Appeals for the Third Circuit. He's also a leading scholar of criminal procedure. Jeffrey Fisher is professor of law and co-director of the Supreme Court Litigation Clinic at Stanford Law School. So, Judge Bibas, in the case of the Bill of Rights, the framers were trying to prevent particular abuses of the government. So what was the historical background that led them to want to protect these rights in particular?
In England, in the late 17th and early 18th century, there was a series of treason trials, other political trials, and the king had done some things that bypassed the usual mode of trial in criminal cases. The Anglo-American system is known as the common law. It involves live testimony in open court before a jury of your peers. And the jury ultimately decides, did you do it? Were you blameworthy? Do you deserve the punishment? Well, the crap.
We're going to stop there, right? The jury, actually both sides, the grand jury and the small jury, is to investigate the facts and the law, okay? Just saying. It wasn't the judge, it wasn't the prosecutor. You know, they can kind of make these annexes about the crime or whatever, but the jury is the one that decides whether it has that annexes or not. Okay?
Crown had railroaded some of its political opponents, people like Sir Walter Raleigh, people accused in the Popish plots during the strife between Catholics and Protestants. And some of these convictions were later understood to have been wrongful ones. And so the colonists in England and then in America insisted on protecting against various ways of diminishing or abridging the trial that would be speedy, that would be public, that would be before a jury, that would have an evenly matched prosecution and defense, and would have an opportunity to look the witness in the eye and confront him the way it was always done in England as opposed to on continental Europe.
There is a varied history, primarily in England, of certain periods of time where people were prosecuted in ways that the founders deemed fundamentally unfair. Probably the most notorious example was...
Now listen to the words still very carefully in the writing on there, right? It said before the jury. It's trial by jury. Okay? So there's a little misleading, and I guess that, they're using it as sorry about that thing, Mijiggy. But it's a little bit misleading because most people don't realize trial by jury. And that's our right, not jury trial. That's not a right. That's a alleged privilege under civil.
The Star Chamber. That was a moniker given to a king-run tribunal decades before the founding, where people were picked up and arrested and then sentenced to criminal punishment and sometimes to death without ever having an opportunity to challenge the charges against them, and sometimes not even knowing what the charges were against them. And so that kind of a travesty of justice and abuse of power was probably the foremost thing in the framers' minds.
This was partly for the benefit of the defendant, defendant or the accused, it also was very importantly about protecting the citizen's right to control criminal justice, that it wasn't the king who would do this, and the king couldn't just let his royal officers off. So it's very important.
All right. Again, they're using king, but all for intents and purposes wasn't for the judge. Okay? They're kind of misleading on this king, even though it was the king. Is also in today in this country is making sure the judge don't extend his powers. All right? Don't use that usurpations against us.
Important to look at the Declaration of Independence. A bunch of the complaints in the Declaration are complaints that the king is bypassing these usual modes, that he's protecting his soldiers by a mock trial from punishment for murders which they should commit on the inhabitants of the states, that he's depriving us in many cases of the benefits of trial by jury, and that he has made the judges subject to his manipulation and pleasure because they don't have stable set.
So he did in this one particular deal, he did bring a trial by jury. So that should give people pause out there. Where is my trial by jury? Not a jury trial.
So the colonists were very suspicious of the king's manipulation of criminal justice.
So how does the Sixth Amendment inform how the U.S. legal system works today?
Well, the first important thing to understand is that when the Sixth Amendment was drafted, just like all the other first 10 amendments, they applied primarily only to the federal government, not to state governments. But in the 60s and 70s, the Supreme Court applied all of these rights one by one to the states. So now, because the right...
And there we go, right? Because they went actually back into the 14th Amendment and assert federal powers over the state that constitutionally they did not have that authority. But due to the 14th Amendment, they extended the federal branch unlawfully.
It's applied to both the federal government and to state governments. The Sixth Amendment applies every single time somebody is charged with a crime. And so that starts with knowing what you're being charged with, whether it's by what's known as a grand jury indictment or some other method of accusing somebody of committing a crime. And it continues on with the right to an attorney to...
And there we go. There's a misleading part, right? Supposed to be by a warrant, by affidavit, even by the complainant. We're using indictments now, or not indictments. We're using information. Okay? That's not in the Constitution anywhere. There's a process in the Constitution, the way this is supposed to be done. And this is in the due process. Okay? Indictment is not in the due process. That is the bar union as a whole creating something to make it easier for them. Allegedly.
Present the accused and goes all the way through the decision-making process with how the jury decides whether to convict or not.
Well, this is fascinating.
Again, they said attorney, but it's counsel. And now they're going to redo that later on, bring a counsel in. But a counsel and a lawyer is two different operations. Okay?
But there are a couple of things that I see in the Sixth Amendment that seem like they might be a little difficult to define, particularly the idea of a speedy trial. So what actually counts as speedy?
The speedy trial component is not well defined. The Supreme Court has ultimately said, well, we're going to balance a bunch of factors. How long is the delay? What's the reason for the delay? Has the defendant shown any prejudice from the delay? How long did it take after the defendant requested the speedy trial? And very rarely does the court actually throw out a case based on that. What happens more often is that the defendant makes a request and then judges really try to push the case along to be faster. So
So we have a right for a speedy trial. But then we turn around, we got to ask for the speedy trial. That's not a right. That would be turned into a privilege, people. What it should be done is automatically a speedy trial, and the defense and the prosecutor may agree to slow the process down. You know, they can do that. But as a right, this is the first thing it should be doing right now. All right? Now, if you listen to the words again, it's not for the people. The judges decide what's considered speedy, whether it's going to be 1 year, 6 months of this. Well, that's absolutely vague and ambiguous, absolutely. All right? And I think in the Federalists, in the federal papers and all that, the speedy trial is supposed to be 74 days. Okay? So, even the judge saying it's a year, the federal law is 74 days. Or 70 days, I can't remember now, it's been a while. But, there we go again.
Court has turned it into really focusing on the defendant's interest in something fast, and that matters a lot when a defendant doesn't make bail and is being held in jail pending trial. So those cases will go to trial in a matter of months. A case where someone is out on bail can easily take a year or two before it ultimately proceeds to trial.
What's speedy or what's reasonable in 1791 might not be speedy or reasonable in 2017.
But what's reasonable is no factors when there's a right involved, people. And this may shut off at any given time, okay? You cannot change a right. Well, they can't, but they're doing it. So, we're going to go ahead. I talked too much in this one, but I just want to make sure it's a little bit on the clear side of these things. Okay? And again, I'm not an attorney. I'm not giving legal advice. It's just my opinion due to me looking outside the box. Okay? These are We the People News.